Welcome back to True Law Stories. I'm Ian Garlic, and today we've got some crazy fun stories about, we've got one about Rose McGowan's legal troubles. We've got one about a pretty crazy Korean story, and another story revolving not directly about Jeffrey Epstein and some other things going on there. But before we get started with Natalie Harris, we are going to, don't forget this is brought to you by videocasestory.com. One of the best ways to promote your business and your law firm is through your client stories, not testimonials. Go to videocasestory.com to learn more about collecting, crafting, and delivering video case stories of your clients. All right. Natalie Harris from Baron Harris Healy. Thank you for joining us here on True Law Stories.
Thanks so much for having me. I appreciate it. Looking forward to it.
Natalie's already at points in my book because she went to school in Wisconsin. Grew up in Wisconsin, so she can't be bad. So Natalie, before we get started with your stories, tell me a little bit about what you do at Baron Harris Healy, because it's interesting.
Sure. We refer to ourselves as a media law boutique. So our clients are anyone in media. So journalists, broadcast stations, radio stations, magazine podcasters, and on the commercial side, advertising agencies and other digital companies. And we basically help them vet their content for legal risks so they don't publish or broadcast anything out in the world that is going to land them in court. And if they fail to consult us on the front end and they are served with a lawsuit arising from something that they put out in the world, like copyright, defamation, invasion of privacy, right of publicity, we defend those kind of cases in court. For the defamation cases, usually on First Amendment grounds.
Gotcha. And so tell me a little bit about, I mean, obviously everyone vets their content and make sure it's not going to cause any lawsuits ahead of time. But
actually they don't, but they should.
They should. What do you see as content producers' biggest misconceptions about their content?
Just a real easy one, low-hanging fruit, hopefully I can save someone a lawsuit on this, is sort of use of photos for people who use still photos and video in their work, whatever it is they're doing. There's sometimes a misconception that if it's sort of out there on the internet, it's yours to use. The idea that the public domain is the same as publicly available, and that's just plain not true. So if you're using a video or a photo or an extended piece of text, something that somebody else created that you don't own, unless you have permission from them to use it, there's a good chance that you're violating copyright law, unless it falls into certain exceptions. One's known as fair use, and a lot of times people will say, oh, it's just fair use. I'm just using it for myself or just to kind of illustrate my story. And again, fair use is a pretty tough defense to assert, and it only applies in certain narrow circumstances. And there's really a new niche industry of plaintiffs, lawyers, copyright trolls who have software that crawls the internet for this kind of copyrighted stuff that is used without a license. And if you get hit with a lawsuit, it should be just a nuisance. A couple $100 license fee is what it's over, but it winds up costing quite a bit because they'll put you over the barrel once you're in court, and it's expensive to make it go away. So that's sort of if anyone could walk away with one piece of advice, don't use content that someone else created unless you have permission.
Gotcha. And that's a tough one too, right? Because especially photographs, I know, people are no problem grabbing stuff off of there. And what are some, you say content without permission. I see all these YouTubers, right, playing videos of like movies and stuff. If you are, that counts, right? Is needing permission.
It counts. And again, like I said, sometimes there are exceptions. There are what's called affirmative defenses if you're using it for certain purposes. The law carves out your ability to use something with the understanding that creativity comes from borrowing other people's work. But for the most part, if you're using someone's content to embellish your own, or just as representative of something you're talking about, yeah, you've got to get a license. Now, just because you're infringing, in other words, using it without a license, doesn't mean you're necessarily going to get sued. In some circles, that kind of sharing is commonplace and understood. It really depends if the person whose content you're using is angry about it and they think they could monetize it, or sometimes it's the flip. They love that whoever is using it because it's getting their message out there. It's amplifying what they want, and therefore they're not going to complain that someone's using it without a license because it's giving them a platform they might not otherwise have. But it's risky, and you should always, when you know for certain that you're focusing on content that doesn't belong to you, you should at least ask the question, is there a risk associated with my use?
Of course, yes. And that's great advice. And so if anyone has this type of advice and is a content, needs someone to look over their stuff, help them with a game plan, that's the kind of things that you help them with, correct? And
absolutely.
It's
Get calls all the time. Hey, can I use this? Hey, this is fair use. Hey, how can you help me figure out if I want to use this and it's not fair use? What can I do to what I'm publishing to put me in the best position to defend my use?
Nice. So yeah, definitely cover your butt, especially, is that federal court when that type of lawsuit? Yeah,
so the Copyright Act is a federal statute, and so there is federal jurisdiction.
Oof. And that
on the
gets very
defense side,
expensive.
we like that because, for the most part, not always, but people who are appointed to the federal bench tend to be incredibly smart people, and so defending, we always prefer to be in federal court if possible, but yes, not when we're defending a troll copyright lawsuit. We prefer not to be in court at all because it's really just a pain for the client. You're going to wind up paying way more money than you would have if you would have just called up whoever owned the content and paid the license fee.
Yeah, that's crazy expensive, I know. I mean, we've got plenty of federal criminal defense attorneys, federal attorneys, and, other IP attorneys as clients, and I know their bills are not cheap.
Find yourself in litigation, right? You better hope you have insurance. That's what I can say.
Yes. So that's bhhlawfirm.com. So Natalie, today we're going to talk a little bit more about your background and some of your cases. Like we talked about the Rose McGowan one. The Korean one's pretty funny. We'll save that for the end. But you were working with a woman who was being sued by her former employer, which is a pretty big name, correct?
That's right. So I represented a woman by the name of Mary Ellen Blair. She was the former executive assistant for Dan Snyder, who is one of the owners of the Washington football team. So he was the subject of an anonymous article that was published in India that made accusations about him that were absolutely untrue relating to Jeffrey Epstein. And he filed a defamation case in India, rightfully so, because there were false statements published about him there. And what he did was filed a series of federal proceedings in the United States seeking discovery, sort of ancillary documents from various people associated with the Washington football team, formerly the Redskins organization, trying to ferret out who, if anyone, may have fed a story like that to the Indian publication in an effort to sully his reputation here in the United States, at the same time that there was ownership disputes going on at the team.
Wow. And so tell me a little bit about what happened. How did this come about?
So the former executive assistant was served with, basically federal court document saying you must turn over endless amounts of information and correspondence and text message you have that, touch on various topics, some of which were, relevant to the defamation case that was pending in India, and some that we felt were ancillary and dealt with her communications with the press about other topics, including sort of harassment and other alleged misconduct that took place at the Washington football team. And so our role when we came in was to help assist the respondent, Ms. Blair, in ferreting out, what information they were seeking. And again, she had nothing to do with the article, which was untrue, but didn't come from her, and sort of vet category of documents they were looking for, anything that she may have done to communicate with India, which in fact there was nothing, from other communications with publications, other people associated with the team that were completely irrelevant to the ongoing defamation case. So we sort of appeared in federal court initially, made some arguments about why it was overbroad, why it was harassing, and were able to negotiate and resolve the matter to both parties' satisfaction.
And it's pretty scary, right? When you get that, when you get that letter, was it a subpoena that she got? How was it served? The equivalent of it. It's a really strange, unique federal proceeding. It's a petition for discovery in a foreign case, but it would sort of appear like a subpoena. In other words, it's a legal document that gets served on you that says you got to turn over all this stuff. So you're absolutely right. A regular person walking around who gets served, with federal court papers saying you basically have to, cut open your phone and computer and dump everything out and turn it over is really terrifying, especially when the person seeking it has a lot of resources and a lot of, access to the media. Can be pretty scary. So I feel those are the kind of cases I like to get involved in, when there's somebody who is facing litigation that they don't have the sort of resources or expertise to defend, and to come in and sort of, they can walk away after having worked with me and exhale, saying, oh, wow, I was, those were some dark times when I was facing that litigation. I didn't know what to do. I felt like I was, outmanned, outgunned, out-resourced, and you were able to come in and help basically tamp down the scope of the litigation, assert some arguments, protecting them usually on First Amendment grounds. In other words, to the extent she was exercising free speech rights and speaking out to others aside from India, which she didn't do, we were able to make some arguments that helped in the negotiations to really narrow the scope of what was being sought and reach an agreement. And in that type of area, like if things would have gone awry for her and she just didn't call an attorney, what are things that could have happened to her?
In all likelihood, there would have been an order entered, basically requiring her to turn over all that stuff subject to a criminal contempt. In other words, if she hadn't cooperated, then she would be in violation of a court order and would be in contempt of court. And my guess is, faced with in a position like that, a regular person would say, I don't want to be in contempt. Here you go. Whatever you're asking for, here's my computer, here's my phone. Take what you want and just leave me alone. And that would have left her in a vulnerable position, having given access and turned over a lot of personal content and communications that arguably are an extraordinary overreach for what, the petitioning party was entitled to.
Pretty much our entire lives are in those communications, aren't they?
It's true, and that's why, it's so important when, somebody is in a position where they're being asked, requested, forced, ordered to turn content over that may have either personal privacy protections or other kinds of protections. If you're a member of the media and you're a reporter and you've got sources who you're talking to, or you've got, communications or documents that were given to you by a source, that stuff is highly, highly sensitive and it's protected. And if you don't have the right counsel to sort of advise you about, what you're entitled to keep private and what you have to give up, you could wind up, damaging a lot of your relationships and exposing content and information about yourself and those who are important to you, unnecessarily.
Now, you don't have to answer this, but this is pretty timely right now because there's a bit of a contempt of Congress case going on, isn't there?
Yeah, it's an interesting test. Now, it's a different system of rules, right? If they were in federal court and Mr. Bannon was on the receiving end of a federal court subpoena, there'd be no question about whether, he was in contempt. But these are different proceedings before Congress. But, obviously, it's interesting because I'm often in the camp of you shouldn't be forced to turn things over. But I don't know that his reason for holding back and not participating is not rooted in the First Amendment, as far as I can tell. So I don't know. My allegiances are perhaps different in a situation like that.
Yes, and and I won't go too deep down that political route, but it's interesting because it's one of those things we don't think about a whole lot, but now information is so much more. I mean, like if handing over your phone records 30 years ago didn't mean anything. It was like you just knew who people called, right? That was it.
Now it's sort of, a web that can be tied to so many other things and can sort of help someone piece together so much private information about you and the people that you're connected with that it's, there's a lot of risk involved and, somebody's personal privacy. So it's really important. And I also think, too, we're in a culture right now where forcing someone to turn over their records is a really, it's a powerful form of retaliation if you're angry at somebody, if you want to shut them up or make them stop talking about you, or that, as a form almost of an extortion. Hey, you said something about me. I know you've got something to say about me. I'm going to force you to stop by basically intimidating you through litigation and threatening you with having to turn over information. And so I think it's so important when someone is in a position like that, where someone is retaliating against them, especially for something they've spoken out about, that they have counsel who can assist and point out to the court that that's what's going on, that this isn't just, this isn't a real defamation lawsuit. The person who's suing hasn't really had their reputation damaged. They're suing to try and shut the person up because they know that the speaker has a lot of bad things to say about them, and they're hoping that if they flex their muscle, that the speaker will disappear.
It's really interesting. And if you all haven't checked it out, we did an episode with Michael Elkins where an employer actually hacked into one of the employees' emails and they found out later on and was doing the exact same thing. And it's amazing because it's scary, and especially if you're the small person, it's scary. But moving forward, not a small person, Rose McGowan. You worked with her. Tell me a little about that story. It's really, really interesting.
Sure. So, most people are familiar with Rose. She's outspoken, activist, actress, and she was identified as one of the silence breakers, one of the first person to come forward and directly accuse Harvey Weinstein of sexual assault. People are familiar with her, and her bravery in speaking out in that way. She was sued by one of these celebrity lawyer types. His name is Jose Baez. People may have heard of him. He represented Casey Anthony, who was on trial for murdering her daughter but was acquitted. Rose had hired him in connection with a matter that she was involved in, and that that matter was being resolved. But while Rose McGowan was still his client, Mr. Baez filed a motion to join the defense team of Harvey Weinstein in the rape case that was pending in New York, and without, asking Rose, or frankly without telling her that his plans were to join the defense team unrelated to her particular situation with Harvey Weinstein, but someone obviously to whom she was extraordinarily adverse. And when she learned of that, she took to social media and gave a few interviews and, referenced his behavior and suggested that he had a conflict of interest. And she also referred to it as fuckery. And one of my favorite legal opinions of all time will be the poor Cook County judge I was in front of, who had to say something to the effect of, I'm not sure exactly what fuckery is, but I can tell you that it's First Amendment protected opinion because it cannot be proven true or false. So we came in basically to defend Rose from the defamation allegations put forward by Mr. Baez, suggesting that her claims when she learned of his decision to work for Weinstein were defamatory. Our position was but they were her opinion. She knew what she knew about him, that he was her lawyer, and that she was that he was going to work for the other side, and so she was entitled to express her opinion about what that was and how she felt about it. And we also discovered that in the actual proceedings in New York, where Mr. Baez had filed a motion to become counsel, the judge who was presiding over those proceedings acknowledged that, in fact, there would be a conflict in the event that Rose was called as a witness in that case, that there would be a conflict of interest and that Mr. Baez wouldn't be in a position to cross-examine her if she was also his client. And so the fact that there was a grain of truth in the fact that there was conflict in the nature of what was going on also, I think, helped our case. But at the end of the day, it was the First Amendment protected opinion argument that carried the day, and that case was dismissed. And Baez, who's, traditionally a fairly aggressive guy, did not appeal. So that was a nice victory.
Yeah, and I mean, he's right down the street from us here in Orlando.
Oh, yeah, right. Right, I forgot about that.
Yeah, Casey Anthony was everything for a while. And how many times did you get to say the word fuckery during that?
Oh, as many times as anyone. Actually, I would say most lawyers don't get many opportunities to say fuckery, but I got to write it in a legal brief and I believe argue it. It was during the pandemic, so it was not an in-person court argument. So I didn't utter it in the hallowed halls of the Cook County Circuit Court, but I did, get to say it in front of the judge.
That's great. And did you have to do research about the word?
Yeah, there's a concept in defamation law called rhetorical hyperbole, and frankly, fuckery is sort of the perfect example of rhetorical hyperbole. It's when someone uses words that, don't have a definite meaning and are definitely used to be inflammatory and to express sort of strong opinion, fiery rhetoric. And traditionally, those kinds of words, rhetorical hyperbole, are protected just for the reason that the judge in Cook County ruled, which is that you can't prove them true or false. And to be defamatory, something must both be false and damaging to someone's reputation. And if there is no clear definition to whatever insult you're throwing at someone, then you can't be held liable. That's thankfully protected speech.
Yeah, and I mean, that could be used as a positive word.
Absolutely. And the best thing is, even if it's not, it doesn't matter, because it's everybody knows that people, scream out things like fuckery when they're angry at somebody else. And the idea of the First Amendment is to allow sort of the discourse of ideas, that if people disagree, you're allowed to get heated and angry and scream things you don't really mean, and the policy is that fosters, communication, that fosters a search for the truth, so that's sort of one of the foundations of democracy, is allowing people to sort of scream back and forth about the things they believe in.
Yes. Love it. That's a really interesting, crazy story. And and that's fantastic. And good job. Good job. Because, definitely deserves to be able to say there's fuckery there.
Right. So feel free, march around. You can feel free, at least in Chicago, to walk around and refer to anything anyone does as fuckery. And at least be protected from the defamation claim, if not getting punched in the face. That I don't know. That's two different types of law.
So finally, I love this Korea story. It's interesting. It's kind of bizarre. But tell me a little bit about why you're working with this Korean company.
Sure. Well, I actually have a background in history in East Asia. I studied Japanese as undergrad. I spent a lot of time in Japan. I taught in Japan.
Awesome.
So it's sort of my side hustle, if you were. The first firm I worked at a law school specialized in representing wholly owned Japanese subsidiaries here. So I always have had an affinity for, finding, since I moved on from that firm, I always like to find cases or clients that have some connection to East Asia, because, it's sort of reminiscent for me, and, culturally I have some familiarity with how dispute resolution works in those cultures. So by coincidence, at my prior firm, we got a case, and this was through an insurance company that insured a local Korean language publication. And based on my sort of affiliation with East Asia, I was put on this particular case, and it was a copyright case. The publication had allegedly taken photographs of, various products that were being advertised without licensing the photos, and the owner of the photos got furious and sued them for copyright infringement, and was looking a little tough because the photos looked like they were the same photos. There was an argument that the copyright registration notation had been removed, which is sort of an escalated penalty if you've done that. And so we prepared for the initial meeting with the client, and I did all the research and tracked all the different images that were allegedly used, and we're sort of going to present a strategy to the client about how we might resolve what was a little bit of a nerve-wracking case because there didn't appear to be a ton of defenses available. And it happened to be January-ish in Chicago, and the client happened to be far out in the suburbs. So it was a planes, trains, and automobiles type of day where through a giant blizzard, we took a cab to the train station, took the train out, tried to get another cab in the suburbs, and, snowy, extended journey. We finally arrived, shook the snow from our collars, waited in the anteroom for the chairman of the publication to sort of meet with us and we could present our strategy. Finally, we were let in and we're sitting quietly and there was some silence. His back was to us in an old-fashioned leather chair and he swiveled around and I sort of cleared my throat and prepared to give our strategy. He looked at us and said, "Make it go away." And then he sort of swiveled back around, and that was it. And I love that story only because I feel like it's such a great lesson in the practice of law. Law students and like new associates work so hard to study and learn everything and come up with a strategy and do your research. And what you sometimes fail to realize is, of course, that is always important to do, and you must always be prepared. But sometimes, especially in litigation, even the best preparation doesn't prepare you for the actual client interaction and what they really want. So you have to learn to roll with the punches and also to sort of respond to what a client wants you to do. He didn't want to hear the story. He didn't want to know the song and dance. He was not at all interested in the Copyright Act. He just wanted the case to go away. And thankfully, we did eventually make it go away, but maybe it might have taken a little longer than he had hoped.
Yes. And I mean, I think that's a good point too, just about clients in general, right? Is like, we just don't know. You got what they really want and what we are going to do are two different things. That's fantastic. Well, Natalie, these have been amazing stories. Once again, you're at bhhlawfirm.com. If anyone wants to follow you out there, where's the best place to follow you personally?
You can check out our website, and we're on LinkedIn, which is not that interesting, but we do put cool stuff that we do up there. We've got news and stories on our website, and I am personally on Twitter. The stuff that I express on Twitter are my own opinions and thoughts, not affiliated with the firm, but if you want to check out some of that content, feel free.
Awesome. We'll put that links in the show notes. Natalie, thanks so much for being on the show.
Absolutely. My pleasure. Thanks so much for having me, Ian, and I look forward to listening to some of the other pieces you do.
Awesome. Thank you. And thanks for taking Natalie and I on this adventure. This has been Ian Garlic and True Law Stories.